All right, so welcome back, and we're going to start now our first tutorial for this week. Okay. Now I'm going to take you through a question we did last week in Springfield, but I want to take you through it one more time because I want to look at a different angle. So it says Jenny, this is from the course book, page 238. Jenny received a circular from Beauty and the Beast hair salon advertising massages and manicures for $10. Realizing that this was an exceptionally good deal, but not surprised because Jenny knew that they had only just opened and were running a number of good opening specials, she rang and made a booking. When she arrived at the salon, she was told that there had been a mistake. That's the one I want to look at. A mistake on the circular. So there was a circular. The circular had a price. The price was $10. That was a mistake. And it should have been 100. The manager of the salon explained that this was still a good price, the 100 that is, because normally a massage and manicure would cost 150. But Jenny was furious. Why? It had taken her 30 minutes to get to the shop by car, and if she had known it would cost 100, she would never have made the booking. Okay? You are asked to advise Jenny. And then, would your advice have been any different if Jenny had the massage and manicure before being told that the cost was 100? Okay, would she have to pay the full price? Let's forget about the last part. I just want to focus on advising Jenny in relation to the mistake. Okay. So, who can give us ideas as to what type of mistake this is? Is this a common mistake, or a mutual mistake, or a unilateral mistake? Before we decide, let's just ask ourselves, what is the mistake?
The mistake is the price that was advertised
On the circular, yeah. So the mistake is that it should be $100, but on the circular it shows $10. Yes? Great. So what type of mistake is this? Is this a common mistake? Both parties are making the same mistake? Is Jenny making a mistake? No. Huh? Is Jenny making a mistake? She just read the circular. It says $10. So who made the mistake? The business, the salon. Right. So what type of mistake would this be then? One party made the mistake. Unilateral mistake. Okay. So what results? If there is a unilateral mistake, how is that going to affect what's going to happen now?
It means the business is liable for the mistake.
So Jenny is saying, you are liable for the mistake. I should get this service for $10.
Yes, because that's what was advertised. It's not Jenny's fault to put on the wrong advertisement.
And what about the business? What would be their argument?
Well, their argument would be that they'd probably be making a huge loss if they were only...
Okay. And what would the court say, you think, when it's a unilateral mistake? Have we looked at something similar just now? Can you go back and check something that I've just talked about? I said I liked this case. Okay, so let's go back and look at Hartog on page 205. So again, I like this case. Okay. So this was the case where they put this price. It's not the $10 and $100, but it was in relation to whether the price is per skin or by weight. Okay? Yes? Do you see the analogy between the question of the salon and this case or not? This is a unilateral mistake. The mistake is about the price, but the mistake in relation to skin, number of skin versus weight of these skins. So, the issue, as was stated here, was it reasonable for the buyer? Who's the buyer in our question in this tutorial?
Jenny.
Jenny. Was it reasonable for Jenny to be aware of the mistake when accepting the offer? We are going to assume that this circular, for now at least, is an offer. When you look at the answer for this, you'll find that it has, you have to look at whether there's an agreement, and then you have to analyze with the two chopsticks whether the circular is an advertisement, i.e. an invitation to treat, or it is in fact an offer, just like Carlyle. You remember? Let's assume it's an offer. You went through that, now you came to this. So, based on our facts, here in the decision they talked about a trade custom. Is there a trade custom in our question?
Yes, because again, in this, the trade custom is that Jenny is trading money for the services.
No, that's what we not what we mean by trade custom. Let's look at again what she's saying. Sure. So we want to see if what she thought was reasonable. Would a reasonable person think what she thought? So she thought, realizing that this was an exceptionally good deal, but not surprised, because she knew that they had only just opened and were running a number of good opening specials, so she rang and made a booking. That's her story. Her story, no, I'm not surprised, because why? Knew that they had only just opened. So, what do you folks think? If someone has taken such services before, or you know what happens when a new salon opens in a local area, would they actually offer you something that's the value of $150 for $10? Yeah. So Shirley says yes, sometimes. Sometimes. Okay. So have you heard of any, for example, pizza deals like that? When a new, for example, outlet opens, like maybe it's a Domino's Pizza or whatever, and they give you these huge deals just because they want to create traffic that we are here,
They're called Lost Lady.
Okay. So would you be surprised if you were Jenny, okay, or if you were a reasonable person? Would you be surprised that they would give you the service that's worth $150 for $10? You'd still be? You'd still think that it is unreal? Okay, so...
She said that I would be giving them good deals on other specials and all that sort of stuff, but this is exceptionally good, unrealistically good.
So a reasonable person would agree or think there's something wrong here?
You'd expect there to be a mistake.
They would expect that there would be a mistake. So I don't mind whichever way you go, whether you go that this is reasonable or this is unreasonable, but you have to see it. You have to spot the issue. So the effect of the unilateral mistake will depend on this idea of what would a reasonable person think. If you look at this, would you think, yeah, that's reasonable, $10? So I'm going to go and drive for how long? For 30 minutes. Okay, I'll make the booking and go. And what else would a reasonable person do?
Pay beforehand.
Could be, but at least you would do what? When you book, wouldn't you actually confirm? Is that something you usually do or not? Usually, someone who's reasonable would say, look, I'm looking at your circular and it says $10 for this service. Is that something reasonable? You start with and how much are you going to charge for it? That's a reasonable expectation. Yes? So that's what kind of stuff you would put in your answer. Okay, let's leave that then and move on to something new. This question is Greta, this is 238, page 238. And this is still chapter 8. So I'm going back and doing some revision. Okay, 238. Greta decided that it was time to sell her car. However, she was not certain of its value. And so, when she advertised the car, she left out the price. Have you seen such ads? Is that reasonable? No? 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 Okay. So, do you get emails from the USQ community or not as students?
Yes.
You get it? Huh? So it said USQ, what it was, community, USQ, the mailing list where people advertise things to buy and sell. Do you get that as students or not? You can actually subscribe to it. Do you know about it? I think it's called US Community something. Notice board. US Community Notice Board. And you would find that sometimes even a car would be sold or advertised and they would say negotiable. Okay? Okay. At least in this scenario, there was no price. Okay? Someone responded to the ad. Sam. Okay? He asked for the price, which is what a reasonable person would do. Now, Greta said, oh, I don't know. Okay? I guess a fair price would be around a couple of $1,000. She doesn't mind, you know, she just wants to sell the car. When Sam arrived the following day with 2,000, she told him that she really meant 2,500. So, does a contract exist? So, this is where I want you to be disciplined, just like in math, like stats. So this is discipline. Don't just start writing. You start by thinking. The thinking means you go with the Wentworth-Miller method. So you start asking yourself. You don't have to write yet. Who are the parties? Obviously, who's going to take whom to court, do you think?
I'd say Sam is going to take Greta.
Sam is the one who might take Greta, saying that I want this car and I want specific performance. For how much? For $2,000. So you know who they are, you know what they want. And what kind of premise are they going to use? Buy, sell. So so we talk about contracts. It says, does the contract exist? Now be careful, because sometimes, as we saw in the negative misstatement scenario just earlier, there could be other things, like contracts, like warranty. So there could ACL. Okay? But let's focus on contract, let's focus on the existence of a contract, so you have to go through the elements. So in your mind, you're going, okay, for a contract to exist, the first thing is that there has to be an agreement. There has to be intention to create a legally binding relationship, and you have to have consideration. Great. So you start with the first element. We need to have an agreement. For an agreement, we need to have what? An offer and acceptance. So again, it's all in your head. You haven't written anything yet. Is there an offer here? Where's the offer? Is the ad the offer? Okay. So someone says yes, someone says no. Okay. So you say yes, Luke. Why do you think the ad is in fact here an advertisement, an offer?
Well,
The general rule in relation to ads is what?
that you're making an offer to sell,
No,
you're making an offer to treat.
an invitation to treat. So it's not an offer. The general rule, an ad is just an invitation to treat. I'm just telling you I want to sell. I'm not saying I'm going to sell it for this guy. So the most important thing, because you, Jackie? Yeah. So you said no. Why do you think that this ad, because Khalil, for example, was an example of an ad where it was an offer. Why do you think this ad would not qualify as an offer? Because, thank you, because there's no price on it. The price is a very important term. When you leave it out, you can't then come back and say, oh, this is actually an offer. So that's not the offer. Okay. So where is the offer now? So the second, someone online? Yes? So the offer then is, let's look at the second paragraph. When Sam responded, he asked for the price. Is that an offer? Okay. Greta responded by saying, oh, I don't know. I guess a fair price would be around a couple of $1,000s. Is that an offer? Why not?
Because she's still not giving exact price. She's just giving a very vague price, like a couple of $1,000s. That could range anywhere probably between $1,000 to $10,000 for all we know. She's not specifying until the day Sam actually comes to sell the car.
I mean, when I say a couple of $1,000s, what do you think I'm talking about? $10,000?
Well,
No.
I always
5,000,
no,
2,000,
because a couple that's
and that's what Sam brought. Sam brought $2,000. I guess around a couple of $1,000s. She said around. Is 2,500 around a couple of thousands? Still?
yeah, it's just a bit above really.
Okay, well, if it goes to 2,600, 700, is it still around a couple of thousand? Pushing the limit because you're halfway through? It's going to be now, a few $1,000s? Okay, so that's the analysis you want to go with. Okay, so where is the offer here? Where do you think the offer is?
When Greta tells them it's actually 2,500.
Okay, perfect. So, Luke is saying that the offer is really at the very end when Greta specifies the exact price she's willing to sell that car for. Okay? Is there now an acceptance?
No.
No, Sam refused, right? Sam counter-offered again with the 2,000. Is there an agreement? Is there a contract? No. Is there an issue here? So that's what you did in your mind. Then you start writing issue 1, okay? Whether, there's an agreement between Sam and Greta. You can refine it. Whether, there's an offer and acceptance, or whether a valid offer and acceptance can be, for example, discerned from the facts in the scenario. Anything like that. It doesn't have to be one particular way of formulating the issue. But what about the second element, which is intention to create legal relationships? Do you see any problem there? What kind of a context are we talking about here? Is this social or business context?
Social.
This is social?
Yes.
They know each other?
No.
They're friends?
No.
How could it be social?
I guess it can't. I guess it is business.
It is business because it's an ad. Someone put an ad and you are just simply responding to that ad. What is the presumption in a business context? That the parties intend to be legally bound. Is there anything here to rebut that presumption? Anything on the facts?
There was no price advertised.
I don't think that's going to rebut the fact that it's a business context. Yeah? So go back and check what we said about things that could rebut the presumption. So I don't think there's an issue on the second element. What about the third element, consideration? So of course, if we would accept that was going to go through, then you'll see that someone is going to pay a price of 2,500, and in exchange for that price, you would get a car. So I don't think there's also an issue in relation to consideration. So in your answer, when you start answering, there would be only one issue for this question. The issue is whether there's this offer and acceptance. You come to the conclusion by looking at the law, what are the rules, and then so you start saying that an advertisement is an invitation to treat, blah, 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 blah. And then you talk about applying that to these facts, and then you'd conclude. That should take you one page. To cover your bases, you can also put, so after that you could say, as far as the other two elements are concerned, okay, which you don't have to go through because you can simply say now that the contract doesn't exist because you failed on the first element. Okay? But to cover the base, you can still say that just one sentence. On the facts, there are no issues in relation to intention to create legal relationships because this is a business context and the presumption is that they intend to do so and there's nothing to rebut it. And then you talk about consideration the same way. So just a few sentences. All right. So it says the price of the car is an essential term for a binding agreement. We know that. So have not come to an agreement unless Sam agrees to the price of 2,500. That's fine. All right, question 5, page 293. So now we are chapter 11. So Washington, an insane person of limited means, entered into a contract with Lincoln for the purchase of an antique axe, okay, and a cherry tree for $100. Okay. The price paid for both of these items was fair and reasonable. And at the time of the agreement was made, Washington seemed to be a normal person. So far so good. Lincoln and Washington. Washington looked normal. Okay. And they agreed on a reasonable price. So far there's nothing strange about this scenario. But subsequently, Washington refused to take delivery of either the axe or the cherry tree, okay, or to pay for them. So Lincoln wishes to know, you are going to advise Lincoln, okay, whether he can recover damages, so monetary compensation for breach of contract from Washington. Okay. He could try also and go for specific performance, but it's going to be harder because it's an equitable remedy. It's all right. So what do you think? What is the issue here? So looking at the existence, we look at agreement, intention, consideration. Anything problematic there? On the facts, do you see any problem with agreement? They entered into a contract. So in fact, they are telling you contract exists. Okay? So you have to say just a few words that on those 3 elements, there are no legal issues on the facts. So you jump into the 4th element, which is what? Capacity to contract. Is there any problem with the capacity to contract here?
Washington's insane.
Okay. So if we say that Washington's insane, then they would have a limited capacity. Why? Because they wouldn't understand what they are getting into. What did you need to establish in order for you to be successful? For Washington to get out of this contract, what do they have to argue? They have to do what? 2 things. Now, first of all, that they are mentally ill, so they don't understand. So at the time, they didn't understand what they were getting into. And the second element is that Lincoln, in this case, knew that they were mentally ill and didn't understand what they were getting into. On the facts, what do you see? Can you make the first element? Is this person insane?
Yes.
Yes, it says that. It says so. So that's not a legal issue. The first element is not a problem. But the second element, on the facts, what does it say? Yeah, so it says at the time the agreement was made, Washington seemed to be a normal person. Seemed to whom? Including Lincoln. So Lincoln would have probably thought this is a normal person. There's nothing, I think, wrong with purchasing an axe and a cherry tree. A normal person would go for it. I don't know. You want to buy an axe, an antique axe, and a cherry tree. Okay.
I don't know, $100.
Okay.
That seems pretty low, but
No, but what did they say? For what was fair and reasonable. Okay. So if an exam question comes and says instead of 100, 1,000, and we omit that part, okay, just cross out all of that sentence. Okay? Start from at the time of the agreement, Washington seemed to be a normal person. Okay? What do you think? Can we make the second element? Is there an issue? I.e. whether Lincoln knew or ought to have known that this person is insane? No? Even though they agreed to buy the stuff for $1,000? Okay. Let's look at what the textbook actually tells us. From the facts, it appears or it's apparent that Washington's insanity is not always obvious. Okay, so the onus is on him to establish what we talked about. He was incapable of understanding, and that Lincoln was aware of the incapacity. If the conversation between Lincoln and Washington's actions would not have alerted Lincoln, or a reasonable person, to Washington's insanity, Washington will be unable to avoid the contract. So remember always that you are looking at this objectively. Someone in Lincoln's shoes, a reasonable person in Lincoln's shoes, would he have noticed that there was something wrong with Washington?
Not necessarily, because again, some people might be medically insane, but they could very well appear to be a normal person.
At least, as they say, not always obvious. Okay. Let's jump to 327. And this is one of the previous exam questions. So I'm not promising you that the Part B exam questions for this semester are going to be from the textbook, but they're going to be similar. I wouldn't bring another exam question from the textbook because I've now opened the textbook for you. So what more do you want? So it would be crazy to actually open the book and then give you exact, and then you have the answer right in front of you, no? Unless I want to be mean and start playing games with I don't want to do that. So you will get something similar. Let's look at this. This came up previously in one of the exams. George is 73, okay, and in the mid stages of dementia. Does that mean he's mentally ill?
Most likely not.
Okay.
On the way.
On the way. So at least we know there's an issue with understanding. His wife, on whom he had relied for many years, died some 3 years ago. Some 3 years ago. He owns his home outright. So, okay. That is, there's no mortgage on it. And it is currently valued at $450,000. George receives a war widower's pension and has a number of small investments that add up to $400 per week. He is completely reliant on his daughter, Lily, for all his needs. Lily convinced George to approach a finance company, Easy Finance, and enter into an agreement with them to borrow $60,000. She told her father that the money was needed for an operation on his grandson. But it was actually for a business venture that Lily wanted to enter into. So she told her father that she would handle the documentation and the loan repayments once the money was approved, and that he was not to worry. George duly made an application to the finance company with the help, of course, of his daughter Lily, who filled out the entire application. After Easy Finance investigated his financial background, it approved his loan on the basis of his ownership of his house. So the house is a collateral. You don't pay, you lose the house. A first mortgage was taken out over the property as security. So now there's a mortgage on the house owned by the finance company. When George attended the loan company's office with Lily, an employee told him that as the loan was for less than $100,000, it was for $60,000, it wasn't necessary for him to consult a solicitor. Let's read this again. An employee told him that as the loan was for less than $100,000, it wasn't necessary for him to consult a solicitor. Therefore, there was no need to take the papers away to read or to get independent advice on them. Why? Because it's less than $100,000. Further, Lily told him that she had read through the documents and that there was nothing to worry about. Nothing to worry about. George was not told what would happen if Lily failed to make repayments on the loan, nor did he think to ask. So, as you would expect, the repayments on the loan, so the principal plus interest, are $2,000 per calendar month. So 500 per week, and in fact exceeded the 400 pension entitlement that George gets every week. 3 months into the loan, Lily defaulted, and Easy Finance is now threatening to sell George's house. So you need to advise George, considering both common law position and the statutory position. So when they say the statutory position, the first thing comes to mind is the ACL, right? Or other things? Is there anything else that comes to mind? So, what do you see here? So, is there a contract or not? So that's straightforward. The contract exists, so you don't have to go through the agreement, intention, and consideration. Just say something about that. And you have to jump directly to where? Whether George has capacity to contract, right? So we want to see whether the contract is valid. It exists, but is it valid? I.e., can you enforce it in court, or is it void? So we said it's something similar to someone who is mentally ill. Okay. But you can also probably argue something else.
Well, even though it says he's on the mid stages of dementia, it shows that alone might be enough to say he was unaware of what he was doing. And like, Lily, his daughter, is aware of his dementia as well, and she's telling him that it's for operation for his grandson, so that he's actually...
So that's why we say when you start the thinking process, you start with who the parties are.
Yeah.
Who are the parties here? Who is going to take whom to court?
I think George should take Lily to the court.
You think George is going to take Lily to court?
Actually,
He has no one else? Who's going to take her for him to court? He completely relies on his daughter. If there is a conflict, someone is going to take someone to court. Who's going to take whom to court? The finance company and George. Who's going to go to court? George or the finance company?
Is the finance company going to take George to court?
No, I think so. The finance company is the one who's going to take George to court because they want the house. Anyone else that could be involved? Someone said Luke said George could take Lily to court. Okay.
manipulated.
Okay, yeah, let's leave that on the side. Can George take the finance company to court?
Maybe because the employee told him.
So when this employee comes and tells you you don't have to consult, you don't have to get an independent advice, what is that? Misrepresentation. What kind of misrepresentation do you think it is? So you have to analyze it. It could be fraudulent, because then, or it could be innocent, because maybe this is an employee, a new employee or something, just an employee, okay? Or it could be also negligent. Okay? So you can start seeing how important it is for you to think a little bit about the parties, okay? What they want, and then you can think of what premises you could use. All right. In order to avoid the contract, okay, George needs to show that there was an issue with unconscionability. Okay. Now I haven't covered unconscionability here, but we talked about in a previous colloquy, if you recall. Okay, I will cover it in more detail as well when we get to Springfield. Okay, but again, remember that it requires a special disadvantage, similar to the special relationship we talked about under negative misrepresentation. Okay, so at the bottom it says George will need to be able to show that the company either knew of his disability, just like an ill person, a mentally ill, or that it was sufficiently evident so as to make it prima facie unfair or unconscionable, which is the same thing, to accept his agreement with to the contract in the circumstances. So if that's the case, the onus then will be on the company to show that the transaction was fair and reasonable, okay? And failure to recommend an independent advice may be of assistance to this regard. So on George's behalf, it will help him to get to that place. Now, we go back as well to the ACL, which is Schedule 2 to this CCA Act, which is the Competition and Consumer Act of 2010, okay? And that prohibits such unjust contracts. All right, I think we'll park it here. We'll continue on Chapter 12 in Springfield. Next week, people, we will start at 9 o'clock in this place. in the same lecture room. Thanks.